thank you all for joining us here for our second panel today. We're going to talk about experts and working with experts. Let me introduce the panel, again, starting from the audience's left to right. We have Stephanie Schoenwald, and she is a partner at Choate Hall & Stewart, where she counsels biotech and pharmaceutical companies on the strategic development of patent portfolios, patent prosecution, and post-grant patent challenges. Thanks, Steph, for being here. Then next to Steph, we have Douglas Robinson, and Doug is a principal at Harness IP, where he focuses his practice on contested matters in the areas of patents, trade secrets, and trademarks. He works in IP litigation. He works at the PTAB. He works at the Federal Circuit. Doug, thanks for being here.
Thank you, Gene.
Next to Doug, we have Pete Lish, and Pete is a shareholder at McAndrews, Held, and Malloy from Chicago, and he is he works in the PTAB space. He's gained experience in both litigation and patent prosecution, covering a variety of technical areas, and he currently concentrates on preparing patent applications and managing patent portfolios in a variety of technologies, including chemical, petrochemical, energy, medical device, and mechanical fields. Pete, thanks for being here. And last but not least, we have a pinch hitter for Allison, who is under the weather. So Meredith Addy is co-founder and managing partner of Addy Hart, and she is a district court litigator. She does PTAB work, she does Federal Circuit work, and we appreciate you jumping into this panel at literally the last minute. Thanks, Meredith. So what I'd like to do is begin by we can start by getting your preliminary thoughts on the topic, and can go in the order in which I introduce you. Steph, we'll start with you. When you hear the topic that we're going to talk about, which is about working with experts and managing experts and dealing with experts and not trying to let your experts kill your case and all that fun stuff, what is the first thing that comes to mind that you want to share with the audience?
Sure. So before we get started, I will answer your question. I just wanted to say this might be one of the quietest IP Watchdog conferences I've ever attended. Yeah. So if you guys have questions from the audience or anecdotes you want to share that kind of fold into what we're talking about, we would love to hear them and encourage this to be as much of a dialogue as it is a presentation. I mean, we're more than happy to talk for an hour, but we'd also just love to hear about your experiences and what questions you guys have in the space. So please, please, please raise your hand and let us know if you have any questions. Turning back to the topic of experts, the one thing that always jumps to mind for me is that there's often a lot of discussion about whether or not the PTAB got it right. And the expert declaration is one place where you can help them get it right. It is probably the easiest way to help them get it right, set the tone, especially with the technology background, give them the information you think they need to understand the technology, to understand your case, to understand the positions that you're about to take. And it's, for me, it's one place where petitioners and patent owners underutilize a very valuable tool that they have in their arsenal. So really use your experts to help tell your story, but most importantly, help the board understand your technology by utilizing the expert declaration in the correct way.
Steph, if I can jump in here, like you suggested.
Yes, you can.
You said that you feel parties are underusing their declarations, but in most IPRs, there's hundreds of pages of declarations combined from the two sides. So how can you say they're underutilized when I'm sure the PTAB judges feel like they have plenty to read?
Oh, I'm sure. But I think the technology background is one place where I've seen, especially early on, people are just not expanding the right points, right? It's where is the heart of your dispute? Do you really need to explain the entire history of the technology? Probably not, but if it's gonna impact what you almost always have a good sense of what the core issues are gonna be in the technologies that's sort of sitting right there at the heart of the dispute, absolutely you should be explaining that in a way that the panel can understand. And this is not to suggest adding more necessarily, but utilizing what you are saying in the right way to help the panel get to the right answer with the technology.
Okay, great. Thanks a lot, Steph. So, Doug, let's go to you for your preliminary thoughts on experts. You can go in whatever direction you'd like to go, but what do you want people to be thinking about as we start this conversation today?
Well, the first thing I thought about in thinking about this panel today was, the very basic point of choosing your expert. You have to put a lot of time and effort and strategy into choosing your expert. And that includes technical experts. Generally, if there is going to be an expert in IPR, there's going to be at least one technical expert. And the question is usually, do you want this professional expert who this is their job, to be an expert in IPRs or court or whatever, or do you want an expert who's maybe doing this as a side gig? And there's pros and cons of each that we could talk about, but it goes beyond technical experts as well. For example, one of the things that we've done in dealing with cases where we have non-patent literature as prior art is get a librarian to submit a declaration saying that anybody would have been able to find this piece of prior art as of the relevant date. We think about using people like marketing experts to deal with secondary considerations. That'll come later in the IPR, of course. But you need to think about not only the technical aspects, but also proving up the admissibility of your evidence, and you may need an expert for that, and that needs to go in early.
Okay, great. Thanks a lot. Pete, your thoughts?
Yeah, so when I initially saw this topic, I thought it was a great one because the experts are just so important in the IPR setting, as opposed to district court where you have 12 different issues and your expert may be weighing in on a couple of them. You are pretty much using your expert for just about everything in the IPR. The issues are narrow, they're very specific, and so having done a lot of work for petitioners, the first thing you want to do is look for the prior art, but at that same time, you've got to find the right expert. So you've got to get the right art and you've got to get the right expert. And then I think, maintaining the credibility of that expert needs to be at the front of your mind from the very beginning throughout the entire IPR proceeding, and speaking with a consistent voice with the expert. And I think there's ways to do that, and it involves being very involved with the expert right from the get-go.
Okay, great. Thanks a lot, Pete. And last but certainly not least, Meredith, your thoughts as we start the conversation.
So as I look into a looming dispute with both district court and likely PTAB involved, I have to think, what are these experts going to do for me? And is this going to be a situation where I need separate technical experts? Why am I going to need separate technical experts? And quite honestly, I can't answer this question at the beginning. And usually what I do is let the case proceed a little bit, maybe retain multiple experts and get to know them and start to decide how I may want to use one or two or more of them.
Okay, great. Thanks a lot, Meredith. So, Steph, let me come back to you because I asked you to help lead the conversation today. So, where do you want to begin the conversation?
Yeah, so I'd like to hear from the panelists about, again, kind of turning back to the overall idea. I've touched on how I think part of the main purpose of the expert declarations is to help educate the panel, especially in the ways that you want, the pieces of the technology you want them to understand more fully. But, Doug, what other purposes do you see for expert declarations, and how do you understand, how do you think about what should go into, for example, the declaration versus the petition, and how you plan that out?
Mm-hmm. Sure. So, taking the assumption that most IPRs are obviousness cases, your expert, of course, is going to have, the claim mapping, prior art to the claims of the patent. But what I think is most critical for the expert declaration is your motivation to combine, or lack thereof, depending on which side you're on. And the expert is really the person that is in the best position to make that compelling argument for why there is or is not a motivation to combine. That dovetails with your comment about providing background of the technology. They go hand in hand, right? You can do your motivation to combine and background of the technology kind of in the same section if you do it artfully. So those are things you think about, you set the stage, and then later on you can have the expert later in the declaration talk more specifically about motivation to combine, but the stage has been set with the background discussion.
Yeah, I often think that is the way, right? You get the background of the technology to the point where it really feels like the only conclusion you can make is that there's a motivation to combine, or that there's not the motivation to combine. So that when you get to that section, it's really easy to piece that together. Pete, how about you?
Yeah, no, I completely agree with all the comments here. You know, it was talked about yesterday that the APJs, you know enough of the technology to kind of be able to tell whether your expert's credible or not. But it's your job to make your expert credible, and the way you do that is by laying out the background, teaching the APJs, you know, this is the specifics of this technology, and kind of building that case from the background right up through your motivation to combine, your expectation of success. And, you know, I think working with the expert right from the beginning, you know, I almost write nothing in the grounds before I've talked about it with the expert. And, you know, I ask stupid questions because I want to hear the way the expert is going to say something so that we can word it that way. You know, we don't want to have during cross-examination the expert is kind of saying the same thing that you wrote in the petition, but it comes out differently, and now you're on the defensive. You know, so I think that telling that consistent story and a complete story is really the key for, at least from the petitioner side, for an IPR.
Peter, you mentioned that the APJs are technically trained, and that's certainly true. And I always kind of take from that an expert with that's in industry as opposed to an academic is better because the APJs have all been to school, most of them with graduate degrees, and they might not feel like they have as big a gap in knowledge in the academic setting as they do in industry. And I wonder what you all think about that and how that contrasts with the expert that would be good for explaining things to a jury.
Yeah, so I generally agree. I like to find experts that are in the industry or were in the industry, ideally around that time. But, you know, I think the specific experience in that industry is super helpful. The one thing I will say with academics is I have had some success. You know, if the academic is just kind of a general professor, I agree it's probably not the best. But if they have a specific area of research that aligns with the technology, then I think they can give you a very good perspective, and they can be very, very useful experts.
I think it also matters. I see you. I'll come back to you. Thank you. You know, kind of which field you're talking about. Right now in the biospace, a lot of the interesting inventions are originating and coming out of universities, and then you know, either being linked up with big pharma in a collaboration or through an acquisition. So still a lot of times the academics are really great, knowledgeable experts for us. And so, you know, I'm not so quick to say, you know, you don't have industry experience, but, you know, they certainly still have the relevant experience.
Now, professors they're paid to profess, to talk, to know everything. And I find sometimes it's hard to get them to agree that they don't know something, or that they don't have an opinion on something, or to just shut up. And, any comments about that?
Mimi, do you want to talk about prepping an academic expert witness?
Well, and I think we're going to get to some of that dichotomy as we proceed. But I agree with, I think, my panel comments that if I'm in the PTAB, I'm looking for someone with industry experience if I can do that. And a lot of times, some of the technology I've been dealing with lately is sophisticated semiconductor technology, really narrowly defined semiconductor technology, in which you may not find a professor that's exactly on point, and yet you can find someone, you know, in the industry or just out of the industry that is really close to what you're doing. And And I like that because I'm not dealing with an academic who's going to want to show how much he knows or teach somebody something. Because if you're in the PTAB, I don't want you to go to the deposition and teach. I want you to go to the deposition and recite just what I need you to recite. I think one way to look at this is a lot of times I come into a case at the federal circuit, and so what I'm getting is the finished record. And I can tell you very quickly where I think my party lost, and it's because they let their expert witness talk too much in the deposition. And I know we'll get to this more specifically, but I think there's a very, very different skill set that goes into a deposition before a district court, a deposition at the PTAB, and it's the lawyer's job to learn how to control this witness in a way that his testimony is meaningful, his testimony helps the court, but his testimony doesn't ramble on so that it gives away the farm. And that applies to the attorney who is taking the deposition of the other side's expert. I've seen cases get lost. I just had one got lost because the other side's expert is allowed to go on and on and on, and he shores up his case. Because by that time, you've seen the patent owner's response, and you've seen the petition, and you know where the weaknesses are in the case. And so if you don't ask close-ended questions like a cross-examination, that witness is going to shore up he is prepped to shore up his case. And it's, to me, it's a very much more stressful environment dealing with depositions in the PTAB than it is in the district court.
Yeah. So we have a couple audience questions. I'm going to go in the order I thought I saw them. So did you have a question?
Yeah, so I actually kind of dovetails to that. What are your thoughts on putting an expert declaration in with a preliminary response?
I may have a different answer than my colleagues, and generally, depending on who we're representing, but also depending on how good the petition is, we don't use an expert all the time in the POPR. In fact, if I like to analogize it to responding to summary judgment, but it's not exactly the same. So if you have a summary judgment motion, right, you have to create a genuine issue of material fact. So here, they have to find a genuine question of patentability. And so if you can respond to a petition and show based on legal doctrine that they didn't meet the burden, that I think is great. Whereas if you have to put an expert in, you're back to a point where we've got this expert and that expert, and as a board, who do I believe? I need to hear more. And so that's kind of been our strategy lately if we see petitions that will assist us in that matter.
Yeah, I 100% agree. I think the best way to get a denial of institution is to go in and point out mistakes that the petitioner made that they just have not made their case. And there's oftentimes, the petitioner will help you with that. If it's a really solid petition, maybe then you put your expert in, but just to kind of get your case in the APJ's heads, I don't expect to get a denial of institution if I'm putting in an expert report and making counter arguments. The way to get the denial is the legal argument that the petitioner just failed.
Yeah, never say never, but I generally don't do an expert declaration with a preliminary response for the reasons that have been stated. I mean, your first line, of course, is to find some infirmity with their analysis, motivation to combine or what it couldn't combine these references, whatever, that doesn't require expert testimony. Because you're right, if there's dueling experts, then okay, well, let's just institute and go to the full thing. And then, if you make your arguments without an expert declaration in the preliminary response, and it doesn't go anywhere, you still get to do it later, right? And now you've got the estoppel. So I think, generally no expert with the preliminary response.
I would echo what everyone has said with a caveat, which is we have put them in for limited issues. Thinking about motivation to combine, for example, we've had situations where the state of the art has actually changed and they're citing to a particular time frame and either arguing for predictability or unpredictability, but there's later, papers, et cetera, that actually say something in the field changed, which needs to be highlighted so we can get to the right place, and for me, the right venue for that type of limited argument is the expert declaration.
And Steph, the goal there is to avoid institution?
Yeah, to avoid institution if we can, right? And there, I think it's not so much that we're kind of coming up to say there is a question here always, as much as to say there's a bigger picture here. So their fact may be correct that in 2010, the state of the art was unpredictable, right? But now, in 2020, it's completely predictable. We have all this art around this now. It was a fledgling type of technology in 2010, but now we have all this other stuff. Or we might say, look, they say it's predictable, but only 2 experiments have been run, and see all these reviews that talk about that in that little narrow space. Sure, maybe it was predictable, but now you can see all the commentary about how they can't extend that out into related technology. So I think it's just completing the picture.
Have any of you won a non-institution decision that mentioned a preliminary response, a preliminary declaration from your expert?
I have not.
No.
I thought you were going to ask if we've won a non-institution decision without an expert.
Oh, of course, that happens all
Yes.
the time.
That's
And
I don't remember. I'd have to go back and look. I don't know the answer.
And Doug, I assume the reason that you say almost never is because you're wanting to avoid confirmation bias. Is that right?
Yeah, that's right. You always think about it, right?
Yeah.
So it's not like anything else in the law, right? There's very few hard and fast rules. You think about it, but unless there's a very, very compelling reason, which she mentioned one, there may be others, but it's a narrow exception in my view. Another
Exception that we have used, and we got instituted, so but if the prior art is mentioning a specific product, and their expert is opining on what that product could do, if you can't really come in and say that product doesn't do that, but you can get an expert to come in with maybe the product brochure and say, okay, no, that's not how that product worked. And so we've done that in the past, just on that limited area of that specific product that was in the prior art.
Jim, I can now think of one that we did file an expert deck, and it was on a claim construction issue. The other side had construed the claim, and we were patent owner, and came in with evidence and support from the expert that that was not how the term was used in the art at the time, and it certainly wasn't how it was intended in the patent. And again, on that sort of, we won that claim construction, which then the other side had not properly addressed sort of the standard usage in their petition, and so we did not get instituted.
Great. So I'm sure you all know, in the early days, the rule was tie goes to the petitioner's expert.
Yep.
And they, got rid of that rule. Has there been a difference?
Not that I can attribute directly to.
I can't see a difference. Even when you file a POPR pointing out how the expert was conclusory, how the petition relies on, multiple paragraphs of the expert, and the expert isn't answering the petition, fact issue at all in those paragraphs. And we thought we had a really strong case, and we still got instituted.
Yeah. So we have a couple questions over here. I'm going to start with you in the yellow shirt, please.
Sure. So you've got your expert, and you sit down and you work out your theories and arguments, and now you have to do the declaration. Do you think there's a best practice as far as who does that first draft? Do you ever let the expert, him or herself, go off and do that first draft?
I have, yes. I think generally the way that, at least in my experience, it's been done is there are a number of discussions with the expert. You go through basically your outline of what the declaration is going to eventually say, get the expert's thoughts on all of it, and usually an expert will say, I don't think I'm really qualified to write this. Can you basically be a stenographer and write up my thoughts? And we'll have somebody do that. And it'll go to the expert, and it'll get edited, and it'll go back and forth. Some experts like to write their own declarations. This is mostly the professional expert who has a lot of experience doing this. And that's fine if they're competent to do it. Most are not. They just don't understand the legalities and the details that necessarily need to be in one of these things.
I can only think of one time I had someone do like their own first draft, and it went fine with that person. They were sophisticated enough to have pulled it off. Most of the time we do varying degrees of exactly what Doug said, which is either have some sort of outline or written up thoughts and say, please put this into your own words. I don't know how your practices may or may not differ.
Yeah, I mean, I agree. I tend to not use the professional experts, and so I don't think I can't recall a time when the expert actually did the first draft. Does involve a lot of back and forth before, I start writing it. But then the one thing I'd add is there's back and forth with edits, but then at the end I like to, pre-COVID it used to be, I like to get in a conference room with the expert and go through paragraph by paragraph and just make sure, because when they're reading it, you send them the document, it's just human nature. They're going to read it. They're going to start skimming certain things that they think they know what it says. But when you're in a room and you're talking about each paragraph, and it generally takes a day. I mean, this is not a short process, but you're making sure that it's in their words. And when they're there, they have no problem saying, oh, no, let's reword it. It's up on the screen. Let's just do it. It's a little harder now because we tend to do it via Zoom or WebEx, but I think that's a huge benefit to just kind of safeguard the declaration.
If I could add one point to follow on to that. It's absolutely critical that your expert owns their declaration. They consider it to be their own. It's not something that the lawyers put together for them to parrot. They have to own it because they're going to have to defend it in deposition. And if they don't own it, they might walk away from it in deposition, and that's not good.
I have a anecdotal story on that. I was in a large joint defense group for about 2 years on both litigation and on IPRs, and so we were handling some of the IPRs. My firm was the lead, and then obviously other firms were the lead on other IPRs. And we did exactly what we've been talking about here. We worked back and forth with our expert, to get our declaration. It worked as usual. The other firms didn't, and they hired very professional experts. They wrote the declarations for them, and obviously the experts signed off on them. And there were two major results that I don't ever want to see again. One result was getting that expert up to speed before his deposition was atrocious. Especially when you have a headstrong guy who is really a professional expert, and you've got to now get him to use the language that the attorneys chose, and that doesn't work. Also, he's a very busy man. He doesn't want to spend a day or two in prep with you because he knows his stuff already. So he's not going to do that. And then you're going to go in the deposition and you're going to get surprised. Yeah. The other thing I saw, and you may have experienced this too, is holy crap, the bill from the expert is out of control because you didn't use him to write the damn thing. Excuse me. You didn't use him to write the declaration like you should have. And now, in this joint defense group, we had to split the bills evenly for our experts. And the experts' bills coming from the ones that were done like that were extremely high, getting the expert on board and ready for his dep. So it was scary during the process because we were like, oh my gosh, what are we going to get in deposition? In the end, we did very well. We were petitioners, and my whole firm was saying, wow, this is really fun and easy. But but that part of it, I use that as my kind of guidepost to say, you got to work carefully with your expert from the beginning.
Yeah, usually the professional expert like that is the one that needs less hand-holding. So that's a horror story.
But he's got to be on board. You
Absolutely.
can't let the attorneys do the majority of the drafting and then he just signs off.
Absolutely.
I think there's a question over here. Yeah.
I had a question. We talk about holding the expert declaration until after institution. If you have faced situations where you had a strong petition, and because you didn't want to, maybe the main issues like motivation to combine, which to me seems to be right before expert testimony, have you ever not filed a patent owner preliminary response? And so you would hold your cards and take the deposition of the opposing expert first before you have your expert prepare his declaration?
Early on, I think that there was a mentality of let's not show our hands, so people didn't file POPRs as much. And then I think the next wave of strategy was, go all in on your POPR. So you got an expert report, you got everything good. And then now I kind of think the strategy is go in on a POPR, but try to hold some of your weapons.
How does it play out in your experience with what folks have talked about with confirmation bias?
That's always a problem. It's a problem.
Yeah, my default is that we'll probably do a preliminary response unless there's a strategic reason not to. I agree with you. Early on, it was a strategy not to hold your cards, but I think we've seen it where there are some arguments that have success at that level, mainly evidentiary or combination issues that don't require an expert, where you can get it in and just get a kill shot. If you don't have that, just save it.
Picking up on other themes from the panels overall, I mean, I do think it's worth thinking about the full case early on, right? So it's not that, we're like, we're holding back because we haven't fully developed it. Almost always we would write out, maybe not in final form, but in some form, the entire POPR, and including where we would want expert support. And we're talking to an expert for sure, right? Are we in the right spot? Is this if this is the case we're going to go forward with, what will you say? How will we support this? And then we trim back, right? It's, okay, what do we think is going to be successful at this particular point? What maybe we don't want to run quite yet, and then we press forward. But the strategy is, a little bit more complex than just holding, kind of holding back the cards. It's much more, we almost think through the whole case, and get the expert on board with the whole case, and then whether we actually put everything in is the real question.
Yeah, I agree. I've actually seen where the kill shot chance during the POPR became maybe slightly inconsistent with the eventual position that was taken with the expert, and that's just, you're set up right there, and it's avoidable just by getting all your ducks in a row early on. But the tendency, I think, sometimes, maybe you got a petition out of the blue, you're rushing to get a POPR in, you see a nice, easy a chance, and you take it without doing all the due diligence on how that's going to affect the entirety of your argument should you lose that and it get instituted.
I will also add, one of the frustrating things about doing a POPR without an expert is, say the petition has, 5 grounds, there's several different combinations, there's 35 claims, all you're looking for is a substantial new question of patentability on one claim. So you may be able to get around 4 grounds pretty well, and then that one ground is going to bite you no matter what. And I just find it really frustrating because I think it's really hard to avoid institution when that's the standard. And I know we've all seen these, like we just had district court litigation where we asserted 5 patents and we got 8 IPRs. And so, you got 5 grounds in one and 5 grounds in the other on the same IPR, on the same patent. And I think with the standard, what it is, where the board, has to look at every single ground and has to determine whether to move forward. And as long as it finds one to move forward on, it has to institute on all grounds. I think that the likelihood of getting a denial is slim.
It also just makes it more challenging for the parties to focus on what really matters, right? So I think there's another question over here, yeah.
I would like to hear a little bit more, if you can, about the difference between an expert in the IPR process and an expert in the district court process. And does that also include a former litigator here? We used to really care about expert witnesses and drafts, and what's in the IPR space. Is it each side doesn't really produce it because it's mutually assured destruction, or you really have to care about the drafts that go back and forth between testifying experts and attorneys? Thank you.
Do you want me to start?
That would be great.
Okay.
Thank you.
So I think one of the first questions that comes to mind is, are you going to use the same expert? And it depends, it depends. And so a lot of times I've got more than one expert that I'm using, and they may not be a testifying expert, or they may be a testifying expert. And then I'll watch my PTAB expert, because he's going to go first usually, see how he does, see if there is testimony in there that could be bothersome for the district court. And if there is, obviously I'm not going to ask him to do anything to that. That's his testimony. That's where he is. I'm going to hopefully veer and go the other way with the other expert. I don't worry so much about drafts anymore. We send drafts back and forth pretty easily, and I haven't had an opportunity in recent years where we've had a problem with the request to produce drafts. I think you got to be a little more careful when you're in a joint defense group, because then you're dealing with that as well. It's another layer or another chink in the armor to be careful about. And I used to wonder what could happen in a joint defense group that causes you to waive that. And I've now just seen it. And it's obviously where one party settles and the other party doesn't. And then the one party that's settling is now aligned with the other side. So you got to be, that's, I think, where you need to be careful, and maybe keep your drafts until the final one circulating within the, the law firm that has primary responsibility. I can't remember whether I addressed all your issues. I have a couple more thoughts, but we'll see how it tracks back around.
Doug, do you have some additional thoughts? And I will say, and maybe it's worth noting that, for example, my practice sits more on the prosecution side with the interface with the PTAB, so this is not a question I would weigh too heavily on. So Doug, I'll kick it over to you.
Sure. So one of the issues is in deciding the expert in the district court versus PTAB is you know, remember your audience, right? Your PTAB panel, they're experts in a field, they're engineers generally. If you have a jury in your trial, district court case, you may want a different expert. That may be where this professional expert who's going to be very smooth and likable and has a lot of experience in front of a jury. That's valuable in front of a jury, not so valuable in front of the PTAB. They just see the record on paper. That none of that really matters. As far as using different experts, I think you consider it for the same reasons you consider using different infringement or non-infringement and validity experts. You know, if one case, one side is a little bit more of a stretch, you don't want that infecting the other side of it. Same with validity issues. If you have additional validity issues, say 112 issues you're going to deal with in court, you may have a different expert deal with those for whatever reason. And to close the loop, as far as drafts, I'm with you. We freely exchange drafts, and it has not been an issue.
So when you have the multiple experts that are going, what steps are you taking to make sure that they're not stepping on each other, they're saying something in a deposition that undermines the other person's testimony? How are you handling that?
You want them in different buckets. So
Yeah.
you don't want both talking about obviousness.
Right.
Okay, you got your obviousness person and you've got your 112 person, and they don't overlap, because if you get that overlap, potential disaster.
Yeah, the one, I have a bit of a pet, issue, which is the 103, 112 interplay, especially in the life sciences space. And I do think even keeping them bucketed, we've seen issues just about what is in fact known and what is predictable, because of course those benefit those two issues in very different ways. So even if you keep them bucketed, is it really just about the strength of the prep? Is it, do you ever let them see each other's reports or declarations if you're at the PTAB? How do you handle just keeping everybody in alignment?
Well, certainly they need to know about each other.
Yeah.
And that goes into the broader strategy. If your expert really has to be a part of your team, whether it's a court case or a PTAB case, they've got to be well integrated and know where they fit in the broader case, both from a legal perspective and what's going on with other experts. So it's important that they talk. As far as exchanging drafts, it'll depend, of course, on how close the issues are.
Mm-hmm.
The example you gave, those would be close issues where there could be inconsistencies.
Yeah.
You would want them talking, and hopefully there's a a line that's not too fine to walk to get through those, but you have to make sure that they're as aligned as they can be.
And I think where you risk getting the inconsistencies is, not so much in the declaration, which is controlled, but in the deposition, and so you have to make sure you're prepping your witness, no matter where you are, in what forum, to deal with these inconsistencies, because a good lawyer is going to seek to pull them out.
So that's a great sort of segue into our next piece, which is how do you, what's the different ways that you prep experts for a PTAB proceeding versus district court litigation, and kind of what considerations are you thinking about as you're going into those depositions and prepping your experts for those depositions?
As I alluded to, a PTAB deposition is a cross-examination, but with an expert, the expert sometimes can get around the questioning of the lawyer, especially if the lawyer is not a really good PTAB deposition taker. So I try to counsel my experts in the PTAB that, you're going to be asked this very direct question. Answer the question and then explain. And, it depends on how much explanation he can get away with and how good the question is coming from the other attorney. If the question's good and tight, he doesn't get as far. But the questions are usually sloppy. And the reason is because we're all taught in district court depositions is you're getting information. You're figuring out how your witness is going to testify later on. So you ask these open-ended questions and try to get all the information you can, but you really got to be a lot more careful in a PTAB proceeding.
I agree with that 100%. And a large part of the prep depends on what type of expert you have. If you have this professional expert, they have more experience. They need less hand-holding. They understand patent law. They understand the technology. And they understand how to deal with the deposition. If you have an expert who's doing this as a side gig, they have to understand not only the technology, they have to have an understanding of patent law, at least for the issues that are involved in the IPR of the case. And they have to know how their testimony fits in with the rubric of the legal standards that are being applied here. And then I think it's also important with somebody with not a lot of experience to do a mock testimony, mock questioning, and maybe have one of your partners come in and do the questioning, so they're the bad guy, and then you can say, okay, this is what we need to do better. I've used that recently, and it was very effective.
So I agree with all that. The one thing I'd add is I think it's really important to have your expert ready and know how to address the kind of fishing expedition questions. So it is a cross-exam, and I think that has got to be front and center in everyone's mind. And so the proper topics for the cross-exam are simply the testimony, which in this case is the declaration. And so, especially when there's a concurrent litigation going on, the opposing counsel will take it as an opportunity to try and score points on various other topics. And you don't want your expert getting up there and saying anything really on those topics. And so making sure that your expert knows, all right, this is limited to my declaration. If I get a question that's not related to my declaration, you're going to hear me object, but ask where in the declaration this is. Ask, for some assistance as to where this is going. And it's fine to say, look, I would want more time to come up with an opinion on that. I can't reach an opinion in the 5 minutes here we've got right here, because I've seen it where I've seen experts that are very ready and very able to keep it within the four corners of the declaration, and I've seen other ones that are happy to expound on topics that you really don't want them talking about.
And to add on to the point about the purpose of IPR depositions being different from district court depositions, that applies to your redirect also. A lot of times, of course, in district court litigation, if it's our witness, they get examined by opposing counsel, and then do we have any questions? Generally, no, right? Unless there's something we really want to get out, or there's something that was just clearly incorrect that they said that can be easily corrected. But no, we'll save our questions for trial. You can't do that in the IPR. You've got to sit and you've got to take your time, and don't be rushed, and come up with your redirect and try to use it as effectively as you can, and think about it like it's a trial.
So I want to return to a topic that Doug raised at the beginning, which is picking your expert. So some of the, and of course we talked a bit about the professional expert versus the non-professional expert, but I'd like to hear from you guys about, how early are you thinking about experts and when are you initiating that search? Are you going through a vendor, or how else are you finding people? And then the vetting process, what are you thinking about as you're vetting someone for ultimate selection as the expert that you use? So, Pete? Yeah.
Sure. Yeah, so some of the best experts that we've ended up with have been through the client. They know the technology. They may know a consultant that they're not working with anymore, or a former employee that they think has a lot of knowledge in this space. I tend to not use the agencies because I don't want a professional expert. It can be hard to find somebody with expertise in a specific area, but especially, as the petitioner, like I said, that's your case. So you really, I think, need to take that effort, and that we do it as basically step one. I mean, we start prior art searching and we start expert searching. And then as far as vetting, I want the knowledge base, but you also have to be careful on the time commitment. We've run into, if you have a medical device case or something and you get a surgeon, a practicing surgeon, good luck getting him to sit down in a conference room with you for a full day to go over his declaration or her declaration. I mean, they have schedules that are busier than ours in most cases. So, somebody that's recently retired maybe has the time and often the knowledge. Honestly, they are kind of looking for something intellectually challenging, and so they want to learn how to be an expert. They want to learn patent law a little bit. So we've had some success there, but it is hard. You want to get the right expert, and it's not a simple process.
We have done it both ways. Excuse me, but I prefer to talk to the client. Usually the client knows somebody, same idea. I know we had a case with some obscure manufacturing, packaging technology a few years back, and we had to go with a service, and they found us a guy who had just retired, and he'd never given a testimony before, and he turned out to be magnificent. So as much as I don't usually like to go with a service, and I think they cost a lot more, this time was really fruitful. And then the strangest place, or that this works, and surprisingly, we had this really narrow area of semiconductor technology that I mentioned earlier, and we were having trouble. It's a defense technology. So as you can imagine, all the experts are consulting for big defense contractors, and we are on the other side. So we couldn't find someone who wasn't connected to a big defense contractor. We went on LinkedIn, and I kid you not, we found our expert on LinkedIn, and he turned out to be fantastic. So don't forget LinkedIn.
Yeah, clients are great resources. LinkedIn is a great resource. Doing Google searches for academics. Look for, whatever your technology area is, look for universities that have departments that are well regarded in that area, and then go through and look at the professors' bios and see who you think may be a good fit. And if they're not, call them. Always call them. Don't email, in my view, because
Agreed.
a call is more likely to at least get returned or answered. But if they don't know somebody, if they're not a good person, they probably know somebody, or they might know somebody, and they'll refer you to that person. I have had good luck with a couple of engineering consulting companies who have a lot of different people in different areas. And if you can get in with one of those, you can, broadly speaking, I have one where if it's a mechanical issue, I know this person can cover it, or this firm can cover it no matter what the specific mechanical issue is. There's another one in the life sciences area that I've dealt with. And finally, the services, in my experience, I have not had great success with the services. I mean, we use them as kind of like the last line if we can't really find anybody else. But I have not, unfortunately, had the experience you did, where they just came through with a rock
Just
star.
one.
Yeah. Yeah.
But I like what you said, and I agree. We try to find them on our own, and we go with the services as a last resort.
And as far as vetting goes, what's everything that's been said is of course correct. But one thing I'll add is that I worry about is is this person, for lack of a better word, malleable? Are they going to be super strident in whatever they say, and they're not going to even change the way they word it, maybe to a way that would be better for the patent context? It's important to have somebody who's strong-willed and able to withstand questioning, but you got to be careful not to go too far in somebody who will just be super, on one path and not change anything at all.
How do we feel about putting in declarations from authors of the prior art?
I jumped all over the other side for doing that, and the PTAB didn't care at all. The main piece of prior art that they were relying on, they got that guy as their expert. And I said, no, he can't testify about that. He's got to have somebody else back him up. He's got to have something else. It can't just be his testimony because he's an interested witness. They didn't care.
Yeah, I've used. I was in a situation where I was concerned about the argument that you're making. So we had the author of the prior art. It was not a patent, but submit a declaration saying what it was, but ostensibly to establish it as publicly accessible and actually published in prior art. We also had an expert who was talking about the expert issues.
It would seem to me that that's terribly self-serving. You ask me, yeah, my stuff's way better than his.
Exactly.
Absolutely.
And this expert, yeah, I mean, he was biased in that manner, but we did what we could to minimize him, and the board didn't care.
What about as patent owner, hiring an author that the petitioner is using against you to say, I hadn't really thought of that. I didn't really mean to imply that. I didn't think anybody would understand it that way.
I got a good war story on that one, unless somebody else wants to go.
Go ahead.
All right, so I have a client that we've now been involved in several litigations and several IPRs. On the first litigation / IPR, we hired an expert, great expert. He was well authored in the field. He did a really nice job, and I would use him again. So then the next litigation gets filed, and my client's exclusive licensee filed that litigation. We didn't want to on-file it, but we got dragged in as the patent holder. So all the IPRs get filed against us, and I said to the licensee's counsel, I'm like, well, why don't you call this guy up? He's like, we did, and he's being used by the other side. So he never showed up to testify because he couldn't testify. He would had to contradict what he had said in the prior IPR, but they retained him immediately so that we could not. And so how does that dovetail into this? He actually, in the second round of litigations, his work was cited as the primary reference in a couple of the IPRs. And so I would have gone right to him. He would have distinguished this work because I knew I dealt with this before, but they retained him immediately.
So I haven't dealt with this exact issue, but the first thing that came to mind is if I've got, the author of the prior art coming in and saying, well, this is what I was thinking at the time, that's not testimony from the perspective of a person of ordinary skill in the art. And so I would argue that it's simply not relevant what you, as the author, may or may not have been thinking. What's relevant is how someone of ordinary skill is going to look at your article and understand it. I don't know if that would
I tried
get
that.
you far.
I tried that in the one where we had the patentee of the main prior art came in as their expert on the other side, and I said that, and it's not relevant at all.
Yeah.
He explained what one of ordinary skill in the art would understand his patent to mean. And I'm like, well, why didn't you put that in your patent? He's like, well, because one of ordinary skill in the art would know. That's what it meant. So I had inherited this litigation IPRs late. I didn't start the game with that. And so I've often wondered, it was past the time to file a motion to exclude this expert. And, I would have done that if I could have, but we tried everything else in the book, but apparently we didn't file a motion to exclude, and the the motion to strike, the patent office is like, the PTAB's like, we can determine this ourselves, right?
That seems to be
Yeah.
their go-to on
Yeah.
this.
That's what happens, yeah. Yeah, it's I can see that being very effective, especially in district court, in front of a jury. I think maybe less so with the PTAB for the reason that you noted. It's more of a fact declaration,
Yeah.
right, than an expert declaration. And I think for that reason, it should be entitled less weight on the ultimate question of obviousness.
I haven't seen the scenario that you're raising, but I would sort of add in another source of evidence potentially that we just haven't been talking much about this conference, which is the corresponding EP oppositions. So a lot of the cases that we handle have, U.S. litigation going on, U.S. PTAB proceedings going on, and then either European litigation or European oppositions. And having authors of papers come in with statements is much more common in an EP opposition, and they can be very helpful to you. They can be helpful to you the EP oppositions can be helpful to you for a number of reasons, among which are the fact that 112 is going to go away in large part. Sufficiency is such a challenging argument to run in an EP opposition, so they're very art-focused. So if you were thinking of filing a PGR on 112 and you want to look at what the other side is saying about predictability and what's known in the art, looking at their corresponding oppositions is a gold mine. Yes.
I have a question back on when we were talking about the difference between experts in the district court and the PTAB. Let's say you're dealing with a particularly weak declaration. Have you ever decided not to go ahead with the deposition, and under what circumstances? Because you don't want them to backfill, you're seeing your, basically, where you're going. So I'm just curious how often, if ever, you decided just not to depose the guy.
There have been rare moments where we've decided not to depose for that exact reason, where like the statements are, what he had to say was perfect all on its own, done. But I don't know if other people have had more experience with that.
Same. There have been instances where I have not deposed the expert just because there's a clear deficiency in it, and we're going to explain that to the board, and we don't want them to backfill.
Yeah, I agree. I also think a point you raised earlier was, kind of not to do any harm, right? And so if you've got a declaration that's light in one area, you might still take the cross-exam, but you might just avoid that area. You or ask very pointed questions, as you put it, where they don't have an opportunity to fill in. Because unlike a deposition where you're fact gathering, this is the record here, and if their expert hasn't sufficiently explained a point, the last thing you want to do is give them an opportunity to do that. So I think that is something that gets lost sometimes and is really important when going into the cross-exam.
And the example I gave earlier where I took the case on appeal and I could go in and I could see, the petition had a weakness, it had a flaw. The expert hadn't opined about a specific limitation, missed it completely. They went in on deposition and the expert backfilled the whole thing and said this missing limitation was actually a part of this other piece he had described ad nauseum, and the board bought it. And the board said it wasn't new argument, and the Federal Circuit just affirmed and said that this is the type of thing that you're allowed to expand upon. So a really directed or not at all deposition of that expert probably would have resolved that problem.
When do y'all choose to do redirect?
Well, I generally will do at least some redirect. It's a lot of it is going to depend too on how your witness is holding up. If your witness has become shaky and kind of frazzled by a full day of depositions, and you're worried about the psychology of the witness, because you have to consider that always. But as long as the witness is holding up, I want to come back in and I want to reiterate the points and say, they asked about this earlier. Does this really matter for your opinion? And hopefully the witness picks up and says, well, no, it's beside the point. These are the reasons for my opinion, and that's just, a distraction. That sort of thing is what I'm looking for in a redirect.
Yeah, I generally will keep it pretty short, and I really am just trying to, I'll kind of have notes, and I don't think I've ever had more than a single page, more than 10 questions or so for redirect. But it's where maybe the expert gave an answer that I think doesn't sound great, right? It could be misinterpreted, maybe it's not the full story, and you want to kind of get out that full story so when you inevitably see the quote in the next brief, you can respond and say, look, that's not the full explanation. Here it is right here. And generally there's not, if your expert is doing well, you don't have too many of those instances.
You have another question?
If you're going to do redirect, do you normally have a conversation with your expert about what you're going to touch upon and how he or she might answer?
Depends on the expert. Usually my ideal is no, okay, even though I think it's allowed, but my ideal is no, because then the question will inevitably come back, well, did you talk about your oh yeah, we talked for 2 hours. No, I want my expert to be prepared beforehand. Like, this is how this is going to go, and depending on how it happens, these are the things I might do afterwards on redirect, and I want you to know that because this is where I want you to go with it. And again, this comes back to the preparation for the expert, and hopefully you can trust your expert to remember that and follow through with it. But that's the ideal situation.
Another question?
So can you talk a little bit about video depths, and do you defend in person, and what your best practices are?
Yeah, I'd say I like to be with my expert, even if the other side is doing it via video. I don't know, I find it helpful to be there. On the other hand, taking a cross-exam of the opposing expert, I don't have as strong of feelings. I don't really have a good explanation for why that is, but there's something about having your expert there that I just feel more comfortable with.
I think it's the body language, right? It's like they can see you like kind of like, I'm going to stop you, or I'm going to object, or we're going to have a conversation. And so there is something, I agree, there's something about being present with each other. And for me, I think it's the ability to sense the shifts in body language.
Yeah, I like to defend in person, but when taking, I've gotten kind of used to not lugging boxes through buildings and security and airports and wherever else.
I agree with those sentiments completely.
So we're gone a couple minutes over, so we should probably try and wrap it up with final thoughts if you guys have any final thoughts. Anyone? Steph, you want to start off with final thoughts?
For me, again, I think echoing a comment I made earlier, it's a lot about preparation. We tend to actually, what we didn't quite get to is have two experts often, one that we're talking to and as they're going to be the person testifying, and one that's backing us up. And I just feel like that degree of preparedness and being, understanding what they're going to say, understanding the full state of the art, and doing so early on in the case is very important.
Great, thanks. Doug?
In my view, what's critical is the expert has to be very integrated into your team, whether it's trial or PTAB. They have to feel like they're a part of it. They have to feel ownership. They have to feel the same desire as the attorney to ultimately come out on top in the end. Because I think without that ownership, the expert is not paying as close of attention. That's where problems happen.
Great, thanks, Doug. Pete?
Yeah, I 100% agree. And to Doug's point, I think, getting the expert involved early, and I don't like going to the expert and saying, here's our position, right? Here's our obviousness position. I like to kind of talk it through with them and let them come to it on their own, because then they own it, right? And it's just, if you put the paper in front of them and say, here's prior right A, here's prior right B, you combine them, you get the invention, they might agree with you, but it's not as ingrained as when, you kind of talk it through together.
Great, thanks, Pete. And Meredith?
I agree with what everyone else said, and I just want to add that from a strategic perspective, this is a developing case, and you may not know until later whether you can use the same expert and to what extent that you used him in the PTAB, which is usually going to come up first, and then back at the district court. And so it's something that I think it helps to be flexible on. It helps to have your pocket expert that you're consulting as well, because many times he can help you quite a bit to sense whether there's going to be some of this tension that comes out between the forums.
Great. Well, thank you very much. We appreciate that conversation. We're going to take a break now. We'll be back in 25 minutes.
Thank you.